Good morning. This is Pat O'Connell calling to order the New Mexico Public Regulation Commission regular open meeting for Thursday, December 14th, 2023. We're in a hybrid format today. There was a 2-hour snow delay, which I think looks like it affected the number of people in the room here, but we're here and safe and ready to go. So, Mr. Cameron, can you call the roll?
Commissioner Ellison?
Present.
Commissioner Aguilera, sorry.
Present.
Commissioner O'Connell.
Present, and thank you for being the latest person to butcher that name.
I know it's taken me a long time,
I
but
got over it.
all commissioners are present and you have a quorum, Mr. Chair.
Thank you. Okay, so we'll rise and do the Pledge of Allegiance and the state pledge. All right, we've got a agenda that was posted Monday morning, and commissioners, do you have any changes you'd like to propose to that agenda?
I do have a couple of suggested changes, Mr. Chair. One of them being the number 2 on the transportation consent action item, the 23-00325. I'd like to ask that be moved to the regular agenda, and I have a similar request for number 5 of the utility matters in the consent agenda, docket number 1593 for the regular agenda. And I did have some comments about a couple of the utility matter cases on the consent action item. So, I don't feel that, that it would impact my vote. So I'd be happy to just discuss those when we get to the consent action items, if that's acceptable.
Yeah, it makes sense to me. Do you have any further changes, Commissioner?
No further changes.
Okay, so I'm going to move that we move forward in this meeting with an agenda that is the agenda that was posted with 2 exceptions. We'll move consent transportation matter number 2 and consent utility matter number 5 to the regular action items. And then looking at the regular action items, Katie Lang is the attorney for all of those items. So we'll just take them in the order they were. But so Katie, I was just making sure you were here. So you're welcome to sit up here if you want to, but so anyway, that's the motion.
I second.
Any discussion? Can we have a vote?
Commissioner Aguilera?
Aye.
Commissioner Ellison?
Aye.
Commissioner O'Connell?
Aye.
The motion passes unanimously, Mr. Chair.
Thank you. Next agenda item is public comment. Mr. Rodriguez, do we have any public comment?
Yes, Mr. Chair, we do have someone signed up on Zoom to provide comment.
Okay, so no one signed up online.
Mr. Chair, yes, we do have
someone. Sorry, I heard no one. Yeah,
audio is not great.
Yeah, just in general, the setup for these meetings, we're not getting the audio in the room very well. So you could hold off a second, Mr. Rodriguez, so we get that fixed so we can hear the public comment. Okay, looks like adjustments been made. Could we go ahead and proceed with public comment?
Yes, Mr. Chair. Athena, are you there?
Yeah.
Yes, I am. Yeah, sorry, sorry. Yes, Athena Christodoulou. Commissioners, just a few weeks ago, I declared my rebellion to you, a rebellion against human extinction due to fossil fuel emissions. Supporting PNM's request to accelerate depreciation of its gas plants to match our need for decommissioning them is right in line with those efforts. Efforts I hope you'll consider. As an environmental and energy engineer, I look for solutions to the problems we humans have brought upon ourselves, especially toxic air pollution and the current climate crisis. I am also a veteran, a retired Navy commander, and so raised my hand to support our Constitution. I'm also a Christian, trying to love my neighbor now and in the future. All exhort me to protect lives. People need clean air in order to live, truly live, not just survive. So anything that hastens the decommissioning of gas plants is a plus for the area and the planet. Fossil fuel emissions account for 90% of the air pollution, creating haze and toxic air. Does our government want us to continue to breathe toxic air, causing premature deaths and any chance of a livable planet for my granddaughter who turns 2 this month? In fact, the newly published benefit cost analysis on gas decommissioning and targeted electrification in Northern California by GridWorks reveals that a state utility, its customers, and ultimately, more importantly, future generations benefit with an all-out approach, decommissioning gas plants in conjunction with targeted electrification. And then there's the more pressing and ominous issue of climate change. How many more Acapulcos, where a hurricane went from a tropical storm to Category 5 in less than 24 hours, with no warning it would even go past Category 2? How many wildfires choking our lungs and destroying our lands? Or how many dry wells from droughts? How many before we act? In rebellion, I exclusively drive EVs, don't fly, and my home is fully electrified. Just recently, I connected my previously gas-heated radiant flooring to a heat pump system that will both heat and cool my house. Pretty awesome. In 2017, I pledged to go fossil fuel-free by 2023, and I made it. But it took money and knowledge. PNM needs money and to be allowed to make use of their knowledge. If we're going to have a fighting chance to address climate change and save the human species, we must all go full speed ahead to reduce our fossil fuel emissions. We need more heroes in this rebellion against human extinction, and I thank PNM for stepping up. Let's all thank them. But hurry. Our planetary systems seem to be spiraling downward rapidly, and this is worth repeating. Don't drill for me, ExxonMobil. I'm a rebel with a cause. I'm against human extinction. Thank you.
Yeah, thank you for that comment. Are there any other public comments signed up?
Mr. Chair, no one online, and I'm not aware of anyone in the hearing room signed up.
Yeah, thank you. We're kind of sparse here in the hearing room, which is good news for me because today's the PRC cookie bake-off, so more cookies for me. Okay, so next is announcements. Do we have any announcements from Office of General Counsel?
Thank you, Mr. Chair. Just that I just wanted to acknowledge my team's efforts over the past month or so to work with the hearing examiners on some pretty important cases, helping them out. And then also just to point out that yesterday was Alejandro Rettig Martinez's birthday. So we can all sing happy birthday. Never mind. That's it, Mr. Chair. Thanks.
Thank you. Commissioners, do you have any announcements?
I do not.
I don't either.
Okay, so I've got a recitation I need to read from a executive session that we had, so I'll read that into the record now. So on December 12th, 2023, the commission met in executive session, which was closed pursuant to NMSA 1978-10-15-1H7, which is meetings subject to attorney-client privilege pertaining to threatened or pending litigation in which the public body is or may become a participant. I affirm for the record that the matters discussed in the closed session were limited only to those specified in the notice and agenda for that meeting. Specifically, deliberations regarding the matter of the application for approval of El Paso Electric Company's 2022 Renewable Energy Act plan pursuant to Renewable Energy Act and 17.9.572 NMAC and 6th revised rate number 38 RPS cost rider. That's NMPRC case number 22-00093 UT and New Mexico Supreme Court case number S-1-SC-39967. And the matter of the filing of advice notice number 69 by Socorro Electric Co-op. That's New Mexico Public Regulation case number 18-00383 UT. And it's New Mexico Supreme Court case number S-1-SC-37948. I affirm that no official or final actions were taken. So then in addition to that recitation, we do have a public, first of all, I'm expecting we're going to have an open meeting next week. So December 21st. And then between now and December 21st, there will be one public hearing that I saw on our master calendar. It's a public hearing in PNM's application for approval of purchase power agreement and energy storage agreement, case number 23-00251 UT. So there's a hearing scheduled in that case to begin at 9 a.m. on Wednesday, December 20th. So if you're interested in that case, there will be opportunity for public comment at the beginning of the hearing, and you can go to our webpage and get yourself registered for public comment. If you don't want to give public comment, but you are interested, then the hearing is also going to be live streamed via YouTube. So you can see that as it transpires live. So anyway, that's it for announcements, I think. So we'll move on to approval of prior meeting minutes. In our packet, we had minutes for November 20th, 2023 public comment hearing and minutes for November 28th, 2023 special open meeting. Are there any proposed changes to those minutes? We move to accept them as we saw them. So I'll move to accept the minutes for the November 20th, 2023 public comment hearing and the November 28th, 2023 special open meeting.
I second.
Mr. Cameron.
Commissioner Ellison,
Aye.
Commissioner O'Connell,
Aye.
Commissioner Aguilera.
Aye.
The motion passes unanimously, Mr. Chair.
Great. Okay, so next we're on to consent action items. Just reminder, we've removed item 8, transportation item A2. Oh. As per usual, I skipped an item on the agenda. We have Chief of Staff Corey here. Could you please announce our new employees?
Good morning, Mr. Chair, Commissioners. We have 2 new employees with us this morning. One I attempted to introduce and I did a poor job of it last time we were all virtual. And so first I'd like to introduce Tatiana Perez Valero to just come up and say hi and introduce herself real quick.
Commissioner Ellison, Commissioner O'Connell, Commissioner Aguilera, it's a total pleasure to be here, an honor for me to work with you in this office and in these exciting times of changes in the energy laws and in its implementation. So I'm really, really happy to be here, and I thank all the persons that were involved in my recruitment for making my dream come true to be able to work in this super exciting field. I'm gonna speak very briefly about myself. I came to this country as a diplomat worked in international organizations before law school, during law school as well. And then I graduated from a public interest law school, CUNY. The best law school ever in New York. After law school, I worked for the city of New York, the Department of Housing Preservation and Development, representing the city in quasi-judicial proceedings. After that, I moved to California. In California, I represented clients in my private practice, immigration, in deportation proceedings and labor commission, other in general, family law type of law I did at the time. Then I moved to New Mexico and worked for the district attorney's office, and then for OSI, Office of Superintendent of Insurance. In there, I had my first experience as a judicial, in quasi-judicial proceedings as well, as a hearing officer, in adjudicatory proceedings and one rulemaking. So that's my experience that I bring to the table. And of course, my 100% devotion to the work as a civil servant. That's it.
Welcome. Looking forward to what you can do. And then just personally, you've been here, what, 2 weeks, 3 weeks?
Yes.
But your positive energy has already lifted the building. So
Oh,
you've already got an accomplishment.
Thank you very much.
Thank you.
Okay.
Mr. Chair, Commissioners, I'd also like to welcome our new Director of Consumer Relations, Ryan Jimenez. Welcome him and welcome him back.
Morning. Mr. Chair, Commissioners, thank you for having me back. A little bit about myself. I'm state government, been in state government for about 22 years, born and raised here in Santa Fe. Have a beautiful family of 4 children. To my beautiful wife, we all live here and raised our children here. I actually left the PRC a couple of years ago. I was here for about 8 years. Started here at the PRC as a transportation investigator. Did that for about 2.5 years. And then came in on the consumer team as a supervisor and acting director for 8.5 years. So I thank you to Corey to have me back here, and I'm honored to be here. It's kind of bittersweet to be here without my buddy David Martinez. But we will be honoring him and doing continuing to do all the good work that this department does. And if there's anything that we can be an assistance of, just let us know.
Yeah, thank you, and thrilled that you're back.
Thank you, sir. Thank you.
Thank you.
Thank you. Okay, so now we're at consent action items. Just again, reminder that we removed 2 cases to regular, and before we proceed to voting on the consent agenda, is there any discussion?
Mr. Chair, I'd like to make a few remarks about a couple of the items on the utility matters section, number 2 and number 4. On number 2, which is case 2099, I notice as we routinely do, we have an order granting disbursement. My comment around that is that I think it would be a good thing if we were able to do an on-site inspection prior to finally, signing off on the final disbursement of these items. I have no problem with agreeing to the proposed order, but just as an overall comment going forward, I think it's something we should consider. And on number 4, with this gas company variance for the December 2023 gas cost factor, this seems to be a recurring issue, and I think what's going on here is that our own rule number 640 is requiring the gas company to give us this estimate of their gas costs 15 days prior to the month. So they had to do it on November 15th for the December gas cost factor. But it looks like it really is too early for them to get an accurate estimate, and they seem to always need to do a refiling later on. And so just as a matter of, procedure, it might make sense to invite the gas company in on one of our open meetings and to ask them, what do they think about the rule 640, and is that 15-day prior to the beginning of the month requirement doing them or us any good. But in general, I have no problem with approving what's on the consent item for that now.
Yes, I appreciate those comments. In fact, I'd had a similar question. We've had a few final disbursements, just because I guess that's just kind of just to that time of year for those kind of things, right? And yeah, so my analogy was, well, I flush the toilet before I pay the plumber, right? So we're not doing that in these cases. So yeah, some way to just verify a project was built and it works. I've had a similar question. Did you have any discussion?
Yes, on both. So as to that one with the broadband program funding, I think it's a great idea to do a site visit. A couple of things come to mind. One of them is to ask our advisory staff to see if we would need to make any rule changes for that. And perhaps not, but and then the other one is whether it sounds like something that would require more money in the budget to do those site visits, but maybe not. And just two things to consider, but I think it's a good idea.
Mr. Chairman, may I provide some? Mr. Chairman, may I provide some information there?
Yeah, anything you could help.
So I believe in the most recent report and recommendation to the legislature regarding the SRUSF, including the broadband program, we included a request, as we have in past years, to the legislature to allow the commission to use I believe $75,000 from the SRUSF fund, because it's not clear under the statute that we could use it for these purposes, but one of those purposes would be to do independent verification of the results of a project. Because at this point, I mean, we have two staff members devoted to telecom, Mike Ripperger and Eugene Evans, and Eugene would probably be making any site visits because he's an engineer. But with just one engineer, it would be tough to do them for all of them. And so maybe having the money to hire an independent evaluator could be the best option.
Yeah, thank you for that, Mr. Fisk.
And then on the, that's the comment I had on that one. I guess I'll pause to see if we have any more discussion on that.
No.
Okay, and then on the variance for the gas cost factor, yeah, I agree with inviting the gas company to come talk to us. We might also benefit first, though, from
some research on that from OGC to so that we have the proper foundation, you know, and understand why this rule became a rule. You know, before we invite the gas company. I think that would help us because they're, you know, I can think of a few very good reasons to continue to require that rule.
Well, I guess my, you know, my concern was not around the rule itself. It was more around this strict 15-day prior to the beginning of the month requirement. So whether, you know, we might want to revisit the, you know, that timing. I wasn't questioning the need for the rule itself.
Okay, thank you.
Any further discussion on the consent action agenda? Seeing none, then I will move to adopt the proposed orders in the consent action agenda.
A second.
Mr. Cameron,
Commissioner Ellison?
Present.
that's an interesting vote.
Allow me to revise that.
Please.
Aye.
Commissioner O'Connell?
Yeah, I mean, that's one of the things college teaches you is half of it is show up, right?
I was happy I could make it to the office today, so.
Same. Commissioner Aguilera?
Aye.
The motion passes unanimously, Mr. Chair.
And thank you for that discussion. So now regular action item, we have 3, and all of them will be a presentation from Katie Lang. So you need a cookie before you start, or you okay? Okay. Okay, so I would, since this is your show, you can take these cases in whichever order makes most sense to you.
Well, let's start with 325 since it's the
Okay, that's the
longest one.
transportation item.
Yes, yes, it is.
That was consent transportation item number 2.
Commissioners, this docket comes before you on the application of applicant All Aboard America. Protester Groom protested the application based on concerns that the applicant was wanting to provide general shuttle service within its service territory. And the staff determined and reviewed the application and the protest and determined the following, which I am recommending, but it's up to the commission's discretion. In relevant part, the Motor Carrier Act specifies that a protest is when a full service motor carrier protests the territory because the applicant is asking to provide service in their territory involved in the application, which is all or a portion of the full service territory of the protesting carrier. In review of the application, staff determined that All Aboard America was not asking to provide shuttle service between the Sunport and Santa Fe. For that reason, staff determined that the protest was redundant and unnecessary. I reviewed that and for that reason adopted the recommendation of let me backtrack here. After the protest, the two parties, the applicant and the protester, entered into a stipulation and agreeing that the applicant would not impinge on the on Groom's territory, and then they motioned the commission to process the application as unopposed. But based on the fact that the original application had never asked to be in the protester's territory, the decision, well, the recommendation is to not accept the protest and issue an amended certificate to the applicant. because it had already, it has an existing number with PRC. And so just to add the additional territories, which is in alignment with its agreement with the New Mexico Department of Transportation and Rio Metro. I neglected, I forgot to say that All Aboard America provides park and ride shuttle services under contract for DOT and Rio Metro. So the question, I guess, is should we reject the stipulation and issue an amended certificate, or does such a action make the the motion where they want to proceed as unopposed, does that make that nullified?
Yeah, thank you for that. Commissioners, did you have any questions?
I did have a few comments, which I think, may lead to some questions. So the issue here is that staff thinks that there is no overlap of the service territories, and so doesn't see a need to accept the stipulation.
Correct.
Is that correct?
That is correct.
But if there's no overlap in service territories, is there any harm in accepting the stipulation?
I don't think there is a harm, but I think staff, I'm speculating here. I think the reason is that if it's not necessary, then why do it? I think is the reason behind the finding it unnecessary.
Okay, but there was a protest from Groom Transportation,
yes.
correct?
Correct.
And if we don't accept the stipulation and just approve the application, then aren't we ignoring the protest?
It's possible that one could interpret it in that manner. That is correct.
And generally with a transportation case, if there's a protest, isn't there a need to have a hearing?
That is correct.
Okay.
Yeah, I guess the question I had with you was similar but different, right? That what they asked for was a certificate, and what we're, based on staff's recommendation, what we're proposing is just an amendment to existing certificate. And so going down that road got into the world of distinction without a difference.
Correct.
And then what I saw as the stipulation is it's a stipulation that's offered for a matter that isn't in controversy. So that's why I understood what staff was saying here, is that the parties to this case created a stipulation when it was not necessary. And so then it's not necessary for us to deal with the stipulation at all.
That is correct.
And frankly, the stipulation was entered into between the two parties. They didn't bother to include staff.
That is correct.
So it's from that point of view, not a very compelling stipulation in the first place. It's a matter that's not in controversy, and there wasn't any apparent attempt to include staff in the negotiations on the stipulation. So I don't see it as an issue, I guess, is where I landed just in research in that. But and then feel free to correct me if I'm wrong here.
Well, I do have a question to that is, as I looked at the, I guess, stipulation, does it technically qualify as a stipulation? Or is it really an amendment of the initial proposal? Was it filed under our stipulation rules? And because I didn't see any of that explained in there.
I cannot give you a watertight answer as to whether it followed our rules, but judging from the fact that staff was not included, I would say that there's a good chance that perhaps it wasn't for our rules, but it looks very much like an agreement between two parties.
Right, and so that's what I'm wondering if, you know, they took the original language and agreed to change it and they, you know, they refiled it and said it's a stipulation. If it doesn't actually qualify as a stipulation, we could treat it as just an amended, you know, amended language.
I guess I'm not clear on the amended, because I don't think they had an original agreement before they entered into a stipulation.
No, I'm talking about the certificate, sorry, an
Oh,
amended certificate.
The amended certificate is, it follows the staff's recommendation. So we did not include the, because the stipulation it was based on this caveat, like, you can do this, but you can't do this. We did not include the limiting language because it was not necessary.
Right. But I guess what I'm saying is that the applicant filed a certificate, right? That said certain words, and then it was protested. The protester and the applicant agreed to revise that.
Correct.
And then they filed that.
Correct.
So
Proposal.
can it be treated as an amended certificate by the applicant, or was it actually filed under our rules for stipulations being filed, and therefore it should be treated as stipulation?
I do not know. I'd have to look into it. I'm not sure about if it was filed within our rules of stipulation.
Excuse me, Commissioners, this is Erica Stefan. Would you mind if I jumped in?
Yeah, please do.
So regarding Commissioner Ellison's question regarding the protest, one of the elements of a protest is that the applicant is impeding on a full service carrier's jurisdiction. In this case, the applicant was not seeking to provide services to between the Sunport and Santa Fe, which was the protesters' objection. And so, like Commissioner O'Connell said, when they entered into a stipulation, they entered into a stipulation over jurisdiction that they weren't actually seeking. And in exchange, that the protester would withdraw the protest. But since that wasn't an issue and the protest is not really valid, there was no protest to pull back. And there was no stipulation to adopt since there was no controversy issue. What staff did was clarify the jurisdictions that the applicants was seeking, so that it specifically leaves out the protesters' jurisdiction. And I use air quotes because we're not using protesters as defined in the Motor Carrier Act, but as just an identifier.
Yeah, thank you for that. Any further discussion or questions?
I would like to ask Ms. Stefan, so is it your view that it was not a valid protest?
It is my view that it wasn't a valid protest because, again, the jurisdictions did not overlap. I think there is a misunderstanding in the application. The application broadly named various counties that the applicant was going to be serving, but into a deeper dive into the application, you would see that they're specifically providing services to specific terminal stops for a park and ride service run by DOT and Rio Metro, which is what staff recommended.
So the parties, though, reached a stipulation, so they evidently thought that there was some issue involved.
It is very curious why the applicant entered into a stipulation that did not include their service area. But the protester filed a response to staff's recommendation and agreed with staff's recommended service terms, service territory, and saying, okay, as staff has recommended with those service territory parameters, our concerns are resolved.
Well, if the protester is satisfied with the language as proposed by staff, then I suppose there's no reason to be concerned about it.
Yeah, and we in working with Katie, I did add information, revised language to that effect, explaining that Groom, while they have some high level issues with staff's approach, they are satisfied that their service territory is not being impacted in this case, and so that has been clarified. But I did want to address one other point, I guess, related to that, is that I do believe that we are responding to the protest in this order, especially as has been revised. I think, and I believe that's sufficient to satisfy the rules, you know, for a protest. I think maybe that's what you were raising earlier, 65(2)(a)(5)(c), which says that the commission shall hold a public hearing on an application whenever a protest is filed concerning the application. Right. Yeah. So I think we're responding to the protest here and have offered the ability to be heard. And given the circumstance here where the protester is saying, actually, this revised language is fine with us, they do still oppose the general approach, but are satisfied, I guess. At least that's how I read their response to staff's recommendation.
Okay, any further questions or discussions? And thank you, Ms. Lane and Ms. Stephans, for that presentation. Seeing no more questions or discussion, I will move to adopt the proposed order in this case.
I second.
Commissioner Aguilera?
Aye.
Commissioner O'Connell?
Aye.
Commissioner Ellison?
Aye.
The motion passes unanimously, Mr. Chair.
Thank you. So then I guess just going in order, might as well do case 15-00093.
Yes, Commissioner. So docket number 15-00093 UT comes before the commission. This docket was opened back in 2015 in order to investigate PNM's station billing practices, specifically statewide, and then also to see how they were billing Valencia Power LLC. And it was also to issue a show cause order against PNM for the alleged failure to bill Valencia service station for services provided between May 2008 and November 2013. However, on April 22nd, 2015, the commission voted to disapprove this proposed order in the docket. And no filings have been made into this docket since April 24th, 2015. It's up to the commission to decide whether we would like to close this docket or not. And the Office of General Counsel has provided a proposed closing order if that is the case.
Yeah, thank you. Any questions, discussion?
Yes, I'd like to make a few comments on this one. I understand this is a housekeeping matter of closing a docket that's been long inactive. However, the matter has come to our attention, and I think it would be interesting to know what the outcome of this case was. I'd like to know if P&M is currently billing Valencia and other peaker plants for the use of power, for the power that these stations consume from the grid when they're not operating. That was not the outcome was not evident from looking at this docket. And I would, since this is not a time sensitive matter, I would propose that we defer this the vote on the order until next week, so that we have time to get a bit more information about that.
Yeah, just looking at my handy dandy Roberts rules, I think that the motion would be to table, and then we can take it off the table in a future meeting. And then personally, I mean, this case is old, so if we do want more information, there's other ways to get that, I guess, without building on putting new information on top of old information. That's why I'd be in favor of go ahead and closing this now. There's nothing to stop us from learning more about the issue afterwards. To me, the risk that I see is just piling new information on top of old information, and that being potentially confusing.
Well, paragraph 4 of the order explains that the commission voted to disapprove the proposed order on April 22nd, 2015. So why didn't that close the docket?
I could not tell you, Mr. Commissioner. It just did. It may have been that perhaps they were waiting on the outcome of the adjoining or parallel docket 14-00102 UT, or perhaps they were waiting on some other order, but I'm not sure why it wasn't closed. But the minute they disapproved the order.
Did that order specifically leave the docket open?
Let me just quickly.
I guess I'm wondering whether this actually still is an open matter, an open docket.
Let's see, the proposed order for the purposes set forth in paragraph 1 is hereby disapproved. The order is effective immediately. Copies of this order shall be served, and it doesn't say if the docket should be remain open or not.
Yeah, my understanding working with OGC, we've had a lot of these. A lot of them, like this one, there just isn't a clear end point of the case. And so that was something that I've been working with Mr. Cameron when we are writing final orders going forward, that we also define how the case closes. It's just a better practice for the future, but we found a lot of these from the past where it's just kind of, why is it still there? It's because it was never clearly closed. Did you have anything to add to that, Mr. Cameron? Because I know your team's been working on a lot of these. Katie was the lucky one to get this one.
Just to reiterate what you said, Mr. Chair, that it seems like at times the orders have not been crystal clear on how they close, whether they should stay open for a certain period of time. And that's something that we have been trying to work on so that whoever comes after us in however many years ago this was, doesn't say, hey, you know, in this position, I'm trying to recreate what happened 8 years ago.
Okay, that's fine. I mean, I think this, just given that background, to me, it sounds like it's close. And I don't, if somebody files something and it's not approved, and the commission issues an order saying we don't approve it, it's not appealed, to me, it sounds like it's closed, even if I don't think we have to explicitly say this docket is closed. So I don't know. We can close.
What the examination was is the commission's been very inconsistent on that. So just trying to get to a page where there's no question.
Yeah, I guess all that to say that if there are some of these that are like this one, at least to me, it seems like it's closed. I don't know why we need to bring these meetings to close them if the commission already acted on them. I think, to me, it sounds like a procedural matter that OGC can take care of.
Good news is we're almost done. So we've had a lot of those in past meetings. I don't know how many of these are left, but that's why I've been calling Mr. Lundin the Terminator, because if you go back through the old agendas, you'll find many with case numbers that are more than 5 years old, and there just wasn't a clear end date, and the things available for you in eDocket as a, so I would say that's part of the practical thing too, is communication throughout the entire PRC that this eDocket isn't open for more things to be piled into it.
Yeah. So I would be fine closing it next week, although if something does come out of this, I feel like, I don't know, it's been dormant for so long. I think that probably should be a new proceeding. But
yeah, due to the age of this, I'm just gonna move that we approve the order in front of us right now. And then that gives total freedom and ability to do whatever we want to do next on this topic. But just get a clean break now and start fresh. So that's why I'm moving to approve the proposed order.
Just to comment, I don't mind closing this out. I may want to ask that P&M do a mini presentation to us, or answer a couple of questions on this matter at another open meeting once we've given them notice that we'd like to do that.
I will second.
Mr. Allison?
Aye.
Mr. O'Connell?
Aye.
Mr. Aguilera?
Aye.
The motion passes unanimously, Mr. Chair.
Thank you. And then I'd encourage, Mark and Judy to work together on how to get your questions answered. Okay, so next, I guess, last item on the action items agenda is a utility matter, 22-00154 UT. Ms. Lane's here to give presentation and answer any questions we have. This is another one where we're closing a docket, and to your point, Commissioner Aguilera, I think it is probably more clear that this one's closed than the Valencia one. I just wanted, in the process of working through these issues, I didn't want to have on consent agenda us closing a document investigating vegetation management plans and procedures without an explanation for why we're doing that. So Since I'm the one that put it on regular action, I'll go ahead and give my explanation, and then Ms. Lane's available for any technical or detailed questions you have. And looking through this was an investigation that utility opened, asked utilities to provide information about their vegetation management plans and procedures. Utilities complied. The information in this docket is very valuable and rich. I think that step, though, was complete. So what I wanted to say here is I think that we should look at what's in that docket when we're moving forward with our reliability standard rulemaking. So anyway, that's the only reason it's on the regular action agenda, was just to have that discussion and alert people to, not that, you know, vegetation management is clearly an important issue. Don't want to make it look otherwise by closing out this case, and then highlighting that the information's there as people are working on comments and NOPR for reliability standards.
You know, that makes a lot of sense. I agree that the information in this docket could be very valuable in the reliability rulemaking, and we may want to incorporate some of the information or all of it in that. It's obviously important for wildfire management consideration, so that information in the record is very valuable, but there's probably no need to have that docket open.
Well, so I do think this one is different than the one we just talked about, because in the other one, there was an order disapproving something. This one hasn't had an order yet. And this left me wondering, well, why was it opened? And then why was nothing ever done with it? This one is not as old as the other one. This one was opened in June of last year, and the responses were filed in July, and then more in November of last year. I see what you're saying. I think it's a good point. I guess I would have preferred to first have a briefing on the information that was provided in all of these dockets.
This docket in particular, this one.
Yes, what teachers look like, and I think that maybe it was something that was provided to the previous commissioners, maybe not sure, but we didn't receive a briefing on that.
Yeah, and that's a good point. I guess my recommendation is that we've opened reliability dockets for rulemaking. So we've taken the next step in the process, and then, I viewed it as question that was asked was answered, is why I thought this docket's worthy of closing. So anyway, I think getting a briefing on and an update on the information that's in here would be a valuable step to take in these reliability rulemaking procedures. So anyway, that's why I'm a proponent of the order that was proposed. I also thought it's worth a discussion in an open meeting.
Yeah,
that thought's been confirmed. So, because as always, I've learned just from listening to your points of view here.
well, I think that we've obviously had some big fires here in New Mexico with Hermit's Peak and Calf Canyon and Recent Mind, and so what I'm interested in knowing is, are there any flaws in these vegetation management plans that we should try to correct, or, you know, if there's any guidance. And that's why I have a little bit of trouble closing it now. I mean, I don't think it's the end of the world if we close it right now. I think we could definitely reopen, issue more bench requests. But, you know, I just feel right now like it might be premature, at least for me, because I haven't gone through all of these plans yet, because it was brought to my attention recently. You know, but if I had the opportunity to go through these, and, you know, maybe I would feel like it, you know, it is ripe for closure.
The good thing is I don't think this is a very consequential decision. This is really more of a housekeeping decision. So I think either way is really acceptable. You know, I guess Commissioner Aguilera, if you have strong feelings and would like to you know, get some presentations and briefing on this prior to closing, you know, I would support that.
Entertain any motion you want to make, Commissioner Aguilera?
Well, I don't know if it's tabling. Can I get some help here, General Counsel? Because the other thing is, staff this month has a lot, and so if I were going to ask for a briefing, I would like to give them more time than, you know, this month.
Yeah, I think, Mr. Commissioner, what you want to do is postpone this matter. If you table it, then it needs to be taken from the table by the end of the next meeting, otherwise it's dead. Okay. So, and given what you just said, it doesn't seem likely that we're gonna, and the breadth of this, the plans and everything, it doesn't seem like that you're gonna get the answers that you want before next week.
Yep. Okay. Then I move to postpone this matter, so that staff could give us a briefing on the information that has been provided in these responses.
A second.
Yeah, thank you for that. And frankly, postpone would have been better advice for Commissioner Ellison earlier in this meeting, I think. So anyway, just wanted to note that I'm still learning here too. But okay, I think we're ready for a vote.
Commissioner Aguilera?
Aye.
Commissioner O'Connell?
Aye.
Commissioner Ellison?
Aye.
Motion passes unanimously, Mr. Chair.
Great, thank you. Thank you, Ms. Okay, so next on the agenda is communications with Chief of Staff. Did we have any communications? Do we have any questions for Chief of Staff? Okay, so next item is communications with commissioners. I try to randomize the order I take these in. So Commissioner Aguilera, do you have any communications with commissioners?
Only to give you an update on a trip that I took last week with the Western Interstate Energy Board delegation representing the BOSSER, the body of state regulators. We visited with FERC and DOE to just explain some general matters about WEEB and what WEEB does for commissioners throughout the West, to support them so that they could continue supporting us. And so those meetings went well. Yeah, that's it.
Great, thank you. And that's frankly a good segue into the trip I thought I should report on that I took last week. I'm now on the member advisory committee for WEC. And so there's class 5, which is the regulators. So the class 5 committee is myself, and then a member of the Utah regulatory staff and a member of the California staff. And then broadly, the job of member advisory committee for WEC is to provide advice to WEC's board. So that was first meeting I've attended in that capacity, and met with Ms. Rennick and Commissioner Throne from Wyoming, who were on their way to DC for the weeb trip. So anyway, that was the link there. At the meeting, it was very informative. There was a presentation and discussion of the Western Assessment of Resource Adequacy that WEC publishes every year, known as the WARA, W-A-R-A. So I encourage you to look that up on WEC's webpage. It kind of shows where things look from a capacity reserve margin. And they new this time broke it down into 3 time periods. So kind of an assessment across WEC, looking at a near term, midterm, and long term view. There was a lot of presentation and discussion on progress that's being made across WEC, being led by staff at WEC into inverter-based resources. So, you know, the inciting incident for that was if your settings weren't correct on your inverter and there was some kind of blip on the power grid, your inverter would just shut down and then didn't come back online. So that's not good, because it would take things like large tranches of solar generation offline when there wasn't really any major condition happening on the grid. So anyway, WEC is in the center of a big conversation to work with industry setting standards organizations like IEEE, and then with groups that manufacture inverters, and then groups that own and operate inverters, to reach common understanding on best practices of what settings to have on inverters, so that inverter-based resources ride through just blips on the grid better than they have in the past. Sounds like a lot of progress has been made on that. And then finally, just commissioner item, I guess WEC hasn't increased its budget for like 10 years. And so they're going through a process of trying to increase their budget. If WEC increases its budget, that's going to increase assessments to members. Members are IOUs in our 2 WEC IOUs would be EPE and PNM. So somewhere in the future, there may be an increase of cost to EPE and PNM because WEC raised their assessment. But I don't think that's going to be material, but just interesting as a commissioner to hear that. Then
quick question. Do you know if the co-ops munis also are members and would need to pay some dues?
Yeah, the co-ops are members and the munis are members. Yeah. And in fact, person I connected with in Salt Lake City is a member, another WEC MAC member from Farmington Electric Utility, and she's a real asset to WEC and the MAC. So nice to meet a fellow New Mexican out there on the road. And then the other thing, and I put this in board effect just so as a way to share the documents with both of you, but if you'll recall, back in July, a group of Western commissioners got together and said, gee, it would be nice if there was at least some competition for Western regional market offerings. And if that competition could include the biggest footprint in the West, that's an attractive thing to pursue. So anyway, commissioners wrote a letter that basically said, gee, it would be nice to pursue the broadest footprint out West. And so that obviously includes California. So from the letter that generated a lot of interest, a stakeholder group has been formed. In kind of the organizer of the stakeholder group is a team called the Leadership Committee of the Pathways Initiative. There's a big stakeholder check-in meeting tomorrow afternoon. So it starts at 11:30 tomorrow. So what I was doing was trying to share with you two the documents that will be given to stakeholders sometime today and discussed at this stakeholder meeting, and then use that as just kind of an update to tell you where that process is at. What the stakeholder group has recognized is if you want to have a regional market that includes California, got to tackle the California governance issues, and my non-lawyerly way of describing that is Cal ISO is a creature of California legislation, and so Cal ISO is governed by a board appointed by the governor of California. If different scenarios are in the documents I gave you of different ways Cal ISO could be included in helping deliver a Western market. So there's just real legal questions about what degree can that happen without changing laws in California, really. So what's going to get discussed tomorrow are different scenarios that things could go forward, and then try to find a legal team to analyze those scenarios to then to say, here's, if you want to follow this scenario, here are the changes that would need to be made in either governance or law, or you have what have you. And at some point there's also going to be, how much would this structure cost? You know, so they're trying to develop just a clean idea of how this idea that's expressed in the July commissioner letter could play out. So that's what you're going to find in those documents, is just kind of where that conversation is at. And then just as an aside, I think it's important to keep everybody up to date with what's going on up there. Also, if this thing proceeds to the point where it looks like it's a real option, I'm going to have to step back, because I don't think that I can. Right now, I've been in an advisory role, which I think is appropriate. Just commissioner should encourage competition and those high level type things that have been going on. But if it ever gets to the point where this leadership team evolves into a group that's making decisions about how an offering can be made, that's a line I'm not going to cross, because I need to preserve my ability. If something forms up out west and one of our utilities wants to join it, I need to preserve my ability to participate in that case. So it was offered in board effect two ways. It's just, if you're bored and want something more to read, you can see what's going on there, and then just give you an update that things have progressed quickly, and there's been a lot of popularity around the question. Things are going to start getting real pretty soon, so we'll see if the popularity translates into action. And once it does translate into action, I'm going to have to be hands off. So those are my updates. Any questions or about that? And then I'll turn it over to you, Commissioner Ellison, and see if you have anything.
I might mention that I attended the gas committee meeting of NARUC on Monday, which was a virtual meeting, and perhaps a little unexpected for a gas committee meeting. NERC was invited to talk about electric system reliability, and they recently did a couple of reports. One of them is their winter assessment for reliability, and also a long-term reliability assessment. And for the winter assessment, they talked about the anticipated reserve margin for SPP being significantly lower than last year. So they kind of raised a flag. Whether or not that is going to materialize into an actual problem is unknown, but the anticipated reserves are significantly less than last winter for SPP. And also in their long-term reliability outlook, they flagged the desert Southwest for in their view, low dispatchable resources starting in 2026 going forward. So they had a concern, they have a concern that the dispatchable resources are being retired and variable resources are being added, and we may end up with less dispatchable resources than is desirable.
Yeah, that the joint FERC-NERC study of deep dive into Winter Storm Elliott. It's I think the title is about power system reliability, but that study was a big topic of discussion in Salt Lake also for WEC, and you read it and it's really a story about the interface between gas as a supply for electricity. So and then if you've been watching what's going on with NARUC, the committee you're on, committee also called GEAR that NARUC has formed. That's just going to be a topic of discussion among commissioners. A lot is electric bulk power system reliability and the interface with the gas system. So yeah, I heard some about that at WEC also, and preview of things to come. You mentioned SPP. That's a big topic for the RSC over the next 6 months. SPP is trying to add, they've always been a summer peaking entity and their reliability rules were written around summer peak. Uri and Elliott highlighted the need to think about the winter too. So just trying to create winter rules for reliability is something that's going on right now. In fact, they just had a FERC filing rejected. I'm sure they're going to refile. And then there's a group within SPP called the REAL Team, REAL, and they're trying to tackle this resource adequacy question holistically. So that's something else that will just roll out over the next 6 months. And Mark Tupler and I are looking forward to being involved in that. So I think the next RSC meeting is in February, so I'll have a report on that when that happens. In any other conversation or discussion? So I guess 2 things before adjournment. I've been alluding to this, but we've been having a December bake-off within the commission. So if you're here, next step is go eat cookies and judge, lest not you be judged. And then the other is I want to recognize we are stepping into the modern world. We have a gavel. I don't know where it came from, but so I will ask commissioners, would you entertain adjournment?
Yes.
And we're adjourned.